Well, good afternoon, everyone. It's very flattering to be asked to speak here. So nice to be amongst so many friends, old and new. So when it comes to enforcement, I have obviously less of a claim to fame than the panel, but I was taught competition law by an enforcer once, so that perhaps partially qualifies at least a few of the comments that follow. When we were preparing for this panel, we realized underneath it all, it's quite difficult for an enforcer to know which tools to use. It's particularly difficult because the bridge between the theory and the practice is relatively weak. In particular, we will highlight the ongoing life that seems to exist in structural views of the market, when quite clearly in the market as it has evolved with consumer preferences and with technological changes, does not always lend itself to a structural analysis. So to give you a quick overview, I promise this won't be death by PowerPoint, but a quick overview. Is the SCP paradigm still alive and well? What's the difference between leapfrog competition and lost competition, a boundary which does not have a clear definition and could do with more analysis, and the implications that that analysis would have for market definition, vertical effects, entry, and finally a few recommendations as we pivot to the panel discussion. I need to do a quick disclaimer for a couple of reasons. One, I'm always warning my students about self-plagiarism, so here is my warning of self-plagiarism. This is based largely on an article I did for Concurrences, which just came out, about digital ghosts in the competition space with AI. Also, I was active in a few cases mentioned, so I have to give the ethical disclaimer in relation to the Anthropic transaction, Google's privacy sandbox matter, and the American ad tech case. Also, in relation to the new UK law, I had the privilege of advising some backbench MPs who caused lots of mischief, so some people around the room will really hate me for that. But all views are my own. Do be aware, though, of the ethical limitations. So, as an icebreaker, since it's getting later in the day, what do Elvis and the structured conduct performance paradigm have in common? Probably the only time that question has been or will be asked on the face of this planet. Well, it's actually very simple. No one's really sure if they're dead. We can proceed the discussion in a more serious fashion by asking, what is this debate not about? It's clearly difficult for people to get to what it is about. But if you've got a trustbuster like Thurman Arnold telling you that you might as well worry about the height of buildings as the scale of firms, I wonder why the scale of firms remains such a fixation. That point seemed to be answered not in 1970, not in 1960, in 1940. In principle, network effects can be positive just as often as negative. In principle, a large share can be helpful just as much as harmful. And of course, there are universes of both. So why the fixation on the negative? It looks a little closed-minded. That will feed into some comments on the Draghi report a bit later. So, as was commented at the time of the bumper crop of reports from 2017 to 2020, many political comments, many political assertions, big is bad, break up Google, Google can't have a browser, how dare they, all of these unresearched points, sometimes bordering the untutored, quite clearly answered at the time by the article by Bill Kovacic and Daniel Sokol, where are the recommendations? Right, this is a classic. This actually does get me a little hot under the collar. It goes back to the greener grass fallacy with Harold Demsitz, right? You don't just go into a policy discussion and say, well, it might be better if you break up Google, but we hear quite a bit of that. Where are the recommendations? Well, without recommendations, you can't distinguish good from bad scale, and that does repeat the errors of the SCP era, which seem to be well known. A more thoughtful discussion is trying to learn from the history, and that could be seen in the parliamentary process for the new UK law. I'm trying to strike a balance today between overemphasizing UK developments and bringing you a few things from detailed work on them. In the debates, Lord Tyree, the former chairman of the CMA, said, "There's no need for a crystal ball." as we have the history. An elegant comment. But where does it take you? Clearly, he is referring to tipping. He is referring to the exclusion of dynamic competitors by platform businesses. And he's drawing on the important work of the CMA from 2019 to 20 in the thoroughly researched market study, so thorough that they ran out of letters and had to go round from Appendix A to Z and back to A again, and then a few more, I believe. So a tremendously thorough piece of work, much debated, and I'm sure many in the room will have views on it. The interesting thing here is that many of the debates in there are actually old debates. I'm not saying that the work wasn't fresh. On the contrary, it updated existing debates to the new era. For example, the classic statement in the American General Dynamics case, as a boss of mine once said, so beautifully named, statistics concerning market share and concentration, while of great significance, are not conclusive indicators of anti-competitive effects. But we do sometimes see that still. Structure, history, and probable future, bringing in things like capabilities analysis, as we heard on the last panel, was even in brown shoe, the most maligned case of all, if you look at the Americana. What's important here, and I'm going to embarrass the moderator of our panel in his own words, is to avoid the arid demand curve. Disruption and discontinuity tend to make a market significantly more competitive, not slow progression along preordained demand and supply curves. Therefore, why are those supply and demand curves so pertinent, so relevant still in documents which, things like the new EC notice, are trying to surpass them, but you still find definitions from actually very old case law. Underneath all of this, there's the issue of not punishing innovation, and no discussion of this would be complete without taking the opportunity to wheedle in the Hamlet reference in the Staples case, which is, I'm sure, familiar to some of you. The two innovators create a new distribution format, just like many online businesses, in that case, distributing office products. It was interesting. The court, as many will know, although it is ancient history, so it may be worth repeating, and we do have a mixed audience, not just lawyers today, so it is probably worth repeating. The two merging parties had created a new format, and Judge Hogan went out of his way to say, I feel like I'm punishing them. I feel like I'm punishing them. He didn't even say that. He said, it feels a bit like the bit in Hamlet where someone gets stabbed. Borderline rude to the agency, but very engaging and very interesting in terms of the insight into the judicial mind. At the end of the day, why are you saying that someone can't have something when they made that very thing? And I always thought that point was put rather well. Going deeper in the American case law, you can find expressions of that that are a bit too strong. I'm reminded of the 1980s waste management case from Dallas, which posited that anyone can enter that market, all you need is a truck. So there's clearly a line to be had between punishing success and unrealistic entry expectations. The question is whether we're on the right side of it. And this takes us to the recent Draghi report. As I think of it, avoiding the museum of Europe. Lots of old train stations running on state subsidy, lots of art galleries, delightful, running on state subsidy, but no new AI company. Well, there are some, but sometimes we pursue them when people are trying to invest in them and help people get their money out. It gives you some pause. There's so much that can be said about the Draghi report. I claim no authority on it, and others around this table have written more about it. But if I'm allowed a comment, it would simply be this. I'm not quite sure that centralizing more concepts into EU law is the answer of a failure which may actually be driven by too much centralization already. That's quite a loaded comment, but I do wonder if some of the competition between different agencies might be quite helpful, creating natural experiments which could then be monitored. That seems to be an assumption underlying the report. Bringing this back to enforcement and the sword and the shield, obviously it's important to distinguish leapfrog competition from lost competition. There are both scenarios, and much of the innovation discussion proceeds without a clear distinction between them. So I thought to get a really nice clear view on leapfrog, we'd go to one of its leading proponents, Joseph Coniglio of the ITIF think tank, who commented at the time that the UK law was passed earlier this year that, since Schumpeter, it's long been understood that competition is not merely, as neoclassical economics holds, an equilibrium where price equals marginal cost. There is the concept of leapfrog competition. Now, you're probably looking at me thinking, why are you stating the obvious? We know about Schumpeter. It's that leapfrog bit. Leapfrog competition is fundamentally different from incremental innovation. It is fundamentally different from optimizing costs for efficiencies. You're talking about a complete revolution in which, from a consumer perspective, the old product is just irrelevant. So let's do some alternative hypotheses. Suppose travel bookings, as in Booking.com, become a completely integrated platform where you just say, Alexa, book me a flight. What's the harm in that from the consumer perspective? None whatsoever. Now that is, of course, a huge leap, and it needs to be taken with caution. But it is important to answer that challenge. It can't just be ignored because of some short-term effects, which may be significantly less valuable to the consumer than the long-term innovation. The truth, though, is that the literature has clearly identified a gap in the analysis. I'll embarrass someone else around the table. This was put very well by someone else around the table who said if only 20% of the resources that have been spent in the last decades on research regarding static competition would be spent on dynamic processes of innovation, a much better knowledge base would exist for a more innovation-oriented policy. Well, I couldn't put it better myself. So here we are doing that work. What would it mean in terms of a sword or a shield? Well, you can run through most of the concepts and find them to be lacking. Of course, concepts often are lacking. Categories are never perfect. The big one is whether market definition is still relevant. We've heard today some very wise comments about market definition in many different directions. There is clearly an attachment to this concept, but strictly speaking, the logic of the new laws is that it's been overtaken. I would suggest that product boundary cases are a good place to see that trend, so we'll spend a little time on them before moving on to some comments on entry. The issues with market definition in platform markets are quite well known. One of the most influential papers is the McSweeney and O'Shea one from 2017. The requirement to prove possibly hundreds of markets wouldn't be a very good enforcement resource use, especially in the context of widespread criticism that enforcement, whether large or small, is too slow. In fact, whatever your view on the merits of the intervention, the unanswered criticism really from reports such as Furman saying that it was too slow seem to be, at least for now, still current. So going out to prove hundreds of markets in a platform market, possibly not the wisest thing. There's also the more subtle tension between different consumers in different markets, which does require considerable attention. It's an analysis which is developing. Indeed, you can see research in progress, analyzing cases like Microsoft Activision, currently going through journals and things like that, in relation to how you relate possibly small losses to one group of inframarginal consumers to a possibly large gain to marginal consumers elsewhere. On this, of course, we have the benefit of new notices and guidelines. The trouble with the new notices and guidelines is that they're slightly out of step with the fast pace of change in the academic literature. For example, the new EC market definition notice still emphasizes the classic definition from Hoffman-LaRoche. Yes, there is good material on supply-side switching in the back end, but I was a little surprised to see that Hoffman-LaRoche retains this relevance. Of course, it's an important precedent. Of course, people have to appear before judges. I don't mean to sound impractical, but perhaps there is a need for a pivot towards more supply-side analysis. Same from the FTC and DOJ merger guidelines. Plenty of threats to innovation, no liberation from innovation. That is quite one-sided. So the new laws seem to imply, at least, that market definition, if it hasn't had its day, should be confined to conventional cases. However, this boundary, for political reasons, was not observed, at least in the new UK law, where the merger provision remains a notification. It's very similar to the DMA position, notification but no substantive change. So does one end up with a tilt towards behavioral rather than structural analysis? That's quite curious because it's particularly difficult to go after mergers, and perhaps rightly, after quite a few difficult cases, complex procedures, things like Illumina, things like the Meta case going to the CMA and back. But you can actually see this particularly clearly. With this being an enforcement panel, I'm keen to talk a lot about practical points. And there is a practical point coming up in the US ad tech case. The Google ad tech case is a splendid opportunity for restating some of these matters more clearly to take account of the passage of time. Now, it might be that that waits for the appeal stage, but I'm very hopeful that the static analysis that might predominate in that case is supplemented by a dynamic one. But of course, we'll all have to write in with our Tunney Act comments, won't we, as we were reminded earlier, and send in our research. So that will be a nice opportunity to do that. Equally, though, can you set a consistent market definition, and is it even relevant? Think about the ad tech case in the Eastern District of Virginia. You've got the ad tech stack, and there will be a need to calibrate a market definition that may or may not include competition with connected televisions showing adverts, which may or may not include app-based advertising, in addition to that you see on your browser. If that is so, it's a little tricky to do the pivot to the analogous privacy sandbox case run by the UK CMA, which has very strong market definition analysis. But ask yourself this: does it actually matter from a consumer point of view? This was always the challenge from the economists, and they're right. Yeah? From a consumer point of view, provided there's contestability, provided that there is competition, why would I worry that a different definition was applied? And that should make you suspect the concept a bit. Indeed, in the words of Mike Walker, a prominent voice, if market definition is the focus of the case, then something is wrong. Not saying you shouldn't do it, but clearly saying that it should not be emphasized. It mustn't be the fulcrum. And I must say, it's so nice to be here and to get to say what I always thought as a very junior antitrust lawyer. Why is everyone talking about market shares? Why are they still doing that? If we look to another focal point, product boundary cases, this is where I think the most practical steps could be had in next generation enforcement. There is an underestimated debate about how far tying law is changed to reflect new product dynamics. This shows up very clearly in cases such as self-preferencing cases, how they interact with interoperability, whether platforms must be untied. But there is also a lot of relevance in the new DMCC law, which does require market power effects to be proven across not necessarily product market boundaries, but activity boundaries. And that's significant. It means that that debate about technological tying, which Professor Yu was referring to earlier, will be only more relevant over time. Same with the DMA, and who knows across the pond what might happen. So one of the things that's so interesting in the Draghi report, just to come back to it, is that it identifies vertical implementation of horizontal innovation as a major part of US scale-up success. It's not that people in Europe aren't innovating. The broken lever, he says, is scale and commercialization. A little bit of latitude around verticals, around large companies entering related businesses would seem helpful if there isn't affirmative proof of market power. This is actually something of a litmus test. Could Amazon enter insurance? Well, you'll get the neo-Brandeisians come in, as they were referred to earlier, and say, oh no, that company's got an A in it, so they can't do insurance. Now, that is obviously not the way to run that analysis, but I'm not sure that a clear signal has been given to the market. We've discussed booking already. The AI merger challenges clearly want to prevent tipping, which could be quite harmful in AI, so I'm sympathetic at some level to doing thorough analysis. But the way that that's proceeded, with several of those small merger challenges like Microsoft Mistral, Amazon Anthropic and so forth, seem to deter people from investing, perhaps just because they're big. For example, the Mistral investment was just 1% of company value, I believe. Meta within is another a good example. When we were preparing for this, the comment that was made, why pick that case? There wasn't actually competition going on between them, according to the company documents, as the district court ultimately found. So why that case was chosen is puzzling, and it starts to look like just a warning shot for no particular reason. So summing up, last stop, entry and efficiencies. Some kind of attention here would be very helpful, especially in relation to algorithms, which I know one of the panelists is very keen to touch upon. Draghi has a provocative proposal here, which some of you will have seen, ex post verification of the investments. Very big question about whether that could work, but something on costs would seem to be a better fit for some of these platforms than a relentless focus on market definition, if indeed that is still the case, simply because the excellent point made earlier today that efficiencies are replicable by competitors, if you're getting this right, would then shine through. And that isn't really there all that clearly in the guidance as it stands. So in summary, you'd want a sword and a shield to protect from predation against innovation, just as much as you would want to create a safe space for innovation. It's that safe space, perhaps, that is lacking. So in summary, 3 points. Is there still too much emphasis on relevant markets? Is there still too much hostility against vertical entry just because someone's big? And finally, if entry is constraining, and surely it must be, considering the product innovations that we've seen over the years, why doesn't one ever see that? Why the fixation on the OFT case on Instagram when there is now TikTok? You can ask, in the first week of an antitrust class, you can tell students that there is a debate about Instagram and Facebook, and they look at you and they say TikTok, and you say, you know, the FTC's complaint originally didn't mention the word TikTok, even though it was out, and they look at you like this is insane. But this is at some level how it has developed. So what would truly dynamic analysis look like? We thought we might touch upon the old classic debate around double-click and how that might play out in Anthropic if the conversation takes us in that direction. Anyway, thank you for your attention. I hope that wasn't too much PowerPoint for this late in the afternoon.
Well, thank you very much, Stephen. I think you left no provocative stone unturned in your presentation there, and I think we've got a lot of rich material for this panel, which builds upon the discussions we've had this morning. One of the features of this panel is that there are former enforcers on it, and maybe our hands are dirty through that. We know what's possible, what's not possible. One thing which you've mentioned, Stephen, is the legal framework which we're operating in. It's very nice to think that we could be agile enough to intervene in a market freely as regulators, as competition authorities. No, there is a genuine issue of defense of rights of defense, and a lot of our work has to be evidence-based for that reason. That being said, there's a lot of room for improvement, as has been indicated. We are talking, after all, about searching for effective, timely enforcement in relation to a moving target of rapid technological progress, not just in high-tech companies, but throughout the economy. So I think that if we've talked this morning as if we're only talking about Apple and Google, this isn't correct. We've got to look much more broadly about that. And secondly, in terms of capabilities, it's quite clear that any market analysis, I say this as a business school graduate, is insufficient without a full, structured, visible analysis of the capabilities of the companies. And therefore, I endorse what the conclusions of the last panel was. I say, all that being said, there's distinct room for improvement in the way in which we are tackling, the authorities are tackling cases now. By the way, Stephen, we spent 5 years decentralizing competition law to national competition authorities in the EU, so we thoroughly hope that there will be a lot of innovation from different regulatory authorities, and that's going to continue. As far as Draghi is concerned, well, Mario Draghi has there are many mentions in his competition chapter. There are many different tonalities to it. Some of them ask for more intervention, others ask for less intervention. I think we should read it carefully and analyze what the right response is. For example, if we have an innovation defense, what does that mean? If it's simply an analysis of realizable synergies in a very short term, that's fine. But if it's a statement by the parties, we are going to innovate, well, as regulators, we could say, well, what are you going to innovate on? They say, well, that's commercially sensitive. And secondly, it reminds me of, to quote from Shakespeare again, King Lear's comments, I will do things the light of which I know not yet, but they will be the terrors of the earth. You can't, the analysis, the prospective analysis of innovation in the future begs into question our knowledge of how markets work. The dynamic of leapfrogging, the dynamic of doing something in complementary to what we're doing now.